You remember we once met at this training session or workshop or whatever, and we were told this is not the way to go. What has changed now? Why should we follow this path? You'll have to justify it, because they would have been sensitized before about certain fundamentals. That is why civic education is important. In South Africa, the women's groups in particular wanted to emphasize a gender-responsive civic education. That was their key interest. So young people will also have their own requirements. So it's an important phase, because even the curriculum of what goes into the civic education is contested, what must go in. It must be agreed and then rolled out. After that, the other point of debate is who is rolling out this civic education? Who? So we have teachers, we have universities, you can collaborate with universities, schools and so forth, and you achieve that. That was in the South Africa, the inclusion, rural, traditional communities. You have to go everywhere. People with disabilities and so forth. In South Africa, one scholar said, yes, people were consulted, they had their views, but there was unequal influence brought to bear on what provisions goes into the constitution. And he says political parties tended to have more influence, and that although certain rights, like the environmental rights, children's rights, came from civic society, but most of the rights were basically ensured, the politicians ensured that they were there. So you must also assess the issue of influence. So yes, the final assessment with respect to South Africa, unprecedented civic education nationwide, millions engaged directly, women, youth, persons with disabilities. The process was transparent and participatory, and resulted in a document that was legitimate. You can't do away with politicians. You can't. They will be there. They must be accommodated. They represent constituencies. They represent viewpoints. They have mandates. They should be part of the entirety of the engagement. The Zimbabwean experience got scary on occasions, because what appeared on face value to be people's participation were people being consulted. They reach out in their pockets, they said, yes, what do you want to say? He pulls out a paper and reads the paper. I want this to happen. I want this to be in the Constitution. I want you to abolish the House of Chiefs, or I want A, B, C, D. And they say, okay, we hear you. Why don't you elaborate a bit? 2 minutes. What are you really talking about? And there was no elaboration. You know why? Because politicians wrote some, go and read this at the meeting. So we can learn what not to do, which has happened before. The process must be genuine, the consultation. The rural poor should not be left out, the marginalized groups should not be left out. And inevitably, a constitution is a compromise, because the people must engage and agree and reach a compromise, inevitably. So those key points to take home: you will need creativity and resources committed to this process, which is essential about distribution of power. You must learn from other countries, ensure participation of the people, and you should not rush this process. It happens very infrequently in the life of a nation. If you get it right now, you'll probably not have another constitutional review after 50 or so years. So I've talked about the preparatory phase as the roadmap. I've talked about civic education. I've talked about public participation and consultation. Some countries, when the Independent Constitutional Review Commission of Technocrats came in, like in Kenya, they had months of working behind the scenes. And among the things they were doing, they were mapping what is called constituency group mapping. They will map that you will need the Law Society, you will need the faith missions, they will do a comprehensive list to ensure that all these groupings are involved and so forth, in order to ensure that the public participation is extensive. Because remember, we are chasing only one thing, and that is the legitimacy of a constitution. It must emerge out of the channel as legitimate, and people say it belongs to us. So we may be now in the initiation phase, agenda setting, and so forth. And then we move with the stages as they come. The people must be consulted in various forums, in hotlers, in classrooms, wherever you may find them. And these days with digital transformation, you can also use that to reach as many people as possible, to get as much feedback as you want, and so forth and so forth. And once the data is collected from the people about what they want, it must be analyzed with the assistance of the experts, and then there'll be drafting. And I often say that drafting is a sensitive aspect of the constitutional review process that the people must know about. Nchunga and Moesi and other lawyers that I see who are here, they know that they can spend 4 days or 2 weeks in court arguing about the meaning of where the comma is. Does it separate or does it connect? They can argue about the usage of one word for 2 weeks. They can argue, these lawyers, about the meaning of person. Moesi will argue that it is ambiguous because it says person. I don't know whether it means juristic person or it means the natural person. What am I driving at? I'm driving at that words matter. So when you come to drafting, that process must also be controlled. The people must keep watch, so that what they said is not reversed in what? In drafting. Because drafting goes into what? The actual document that is called the Constitution. Why does that matter? It matters because when you go to court, they don't ask. The court will not ask, what did the people say when you consulted them? What did they ask? What does Section 21 say? So drafting is critical. I earlier said you have to choose whether you do the final adoption or you want the Concord or whatever court to certify the final document. I've talked about civic education, the design and the execution, and so forth. I will give Bokongo all this, they can share with you. It's a very elaborate thing that I prepared. The essence of my talk today is to say that ideally we need a bottom-up, people-driven constitutional review that meets international best practice. And I want to suggest with all humility and respect that for the country to have an enduring and proper constitution, this process should not be hurried. It requires time. If you have to go through all these stages, it requires time. People ask, when you say it requires time, what do you mean? How many years? People ask. It requires a reasonable time, anything between 2 years, 3 years, 4 years, falls within the practice of other countries. I actually believe that within 2 and 4 years, a process properly run can be concluded. But there must first be a plan and stage agreed, even timelines put. We have phase 1, phase 2, phase 3, we'll conclude this within this time. And we can't emphasize more than necessary that the experience of other countries are important, they should inform us. We can't emphasize more than is necessary that put the people at the center of the process so that they can own the constitution. If I were to be asked in a minute to summarize the stage that the people must follow, I would say pass a Constitutional Review Act, set out the process, informed by the inputs of the people, set out the steps, let it become known, become binding, become law, follow that process and conclude. And then you'll have a constitution of the people. We will never agree. That is the beauty of democracy. We can't ever all agree. Never. And it's okay that we don't agree. We must disagree robustly. In a democracy, there must be some mechanism. After we all disagreed on anything, about what is it though that we converge on, a common ground. That is how democracies work. We can't agree. I can remember South Africa, I think they were faced with that dilemma. They were faced with that dilemma. But the activists like Womaud had argued through the various phases of the struggle up to the Freedom Charter and everything that they are for rights. And there was a debate, if you are for rights, then you shouldn't support the death penalty because it violates the right to life. And then he says, no, others said, no, it doesn't. If you kill, what else do you expect? Others said, in a democracy. Not agreeing, right? What did the designers of the Constitution of South Africa do? So what they decided, remember I said something earlier. I said it's one thing to consult, but there was unevenness of influence that ended up in the Constitution. And what was that? The elites and the politicians decided that to avoid the wrath of the people, they will entrench the right to life. There was a debate as to whether the death penalty violates the right to life or not. They decided, we'll not answer this question, but we'll put it in the Constitution. There shall be the right to life. If anyone wants to ask the question whether the death penalty is contrary to the right to life, where does he go? Have I answered you? So what they did, it was a hot potato. So the state versus Makwanyane. I'm sure you heard even the president mention that case. The famous case of state versus Makwanyane. The justices came and said, death penalty violates the right to life. Moesi and many other lawyers who are here may recall why in the Constitution of Botswana, even a judge similarly inclined can't do it. Because the Constitution is expressly clear that in entrenching the right to life, it is not making the death penalty illegal. So it's clear. Otherwise, they could have been judges inclined to the Makwanyani logic. Without that section of our constitution in Botswana, they could have easily come to the same conclusion. What am I saying? What I'm saying is that you, the sovereign, will put into the constitution that which you want.
Yeah.
What about Concord? Mauto, the activists, wanted to put me on the spot. And I've reflected on what I should say. If you listen to me carefully, I said in a constitutional review process, the process is as important as the content. What do I mean by process? Process, I mean step 1, step 2, step 3, step 4. What is my answer? The steps must be determined by the people and the content must be determined by the people. I think by that I've also answered Moise. I did a summary answer to you, Moise.
Yes, my lord.
Yes. Don't contest, don't be risk contempt. Yes, Rorisa, mediation, the communication matters. The medium of communication obviously matter. In South Africa, they engage in all languages across all platforms. All languages, all 11, are they 11? All 11 languages. So the constitutions were translated, leaflets were in all the languages. So the medium of communication matters. Why does that matter? It matters because you want to reach each and every person. I also said earlier, a constitution by definition, because of that we can never agree, is a compromise document. It's a compromise document. Certain things will not be there because the people couldn't agree. But with respect to those that agree, they will be in the constitution. So it's a compromise document. The South African constitution itself was a compromise document because there are certain groups, grassroots groups, who wanted certain things to be in the constitution, but they were not there. So that is why I also say it's also a contested document. And that is why I say it's also a political document. Because you are going to find yourself at the heat of it, going to talk to your relatives in Bobono and asking them that, please, when it comes to referendum, please vote this way. You're going to be doing that in your WhatsApp groups. You'll be lobbying. And ultimately, the majority win in a democracy. One of the things, does the Constitution address contemporary issues, such as culture, I think you said, and digital issues, the issues of now, contemporary issues. The theory of the Constitution is that the theory of the Constitution is that it is an organic document that grows with society. And that because it's organic, it serves not only now, it also, we say, generations yet unborn. We say it should be an elastic document. You should be able to pull it in order the things that were not contemplated, it must accommodate them many years later. But the danger with that is that you can pull the Constitution almost to a breaking point. So hence the review. So in the review, you can then say certain issues that are not find no place in our current judiciary. AI, for instance, is relatively new, and other things. There's a lot of cybercrime and other issues related to the internet and many other things that were not there during the time of the Constitution. You can then expressly legislate, depending on your experience with these contemporary issues. So that's the beauty of the review. It then avoids a situation where the judges make law. Because when the judges start making law, we say they are offending the separation of powers. I often ask, in class and outside class, that we talk about separation of powers. I don't know, Chuchu, Ramanyining, and other students of law who are here. We talk about separation of powers in Botswana, but there's no such sentence in the Constitution of Botswana. So I challenge any constitutional lawyer to bring that sentence to me. There is none. Nowhere does it say it, but it is part of our constitutional reality. Why? Because the judges said, the way we read the flow of the Constitution, the structure, somewhere it creates parliament, it then created judiciary in that section, and then there is the executive, and we see that the executive is dealing with policy, we see judiciary is dealing with interpretation of the law. We have separation of powers. It was by judiciary legislating that it came into being. You want to avoid that. You want to be express about it. Even say its boundaries. I said to Replicano this afternoon, I said you need a public lecture on the Constitutional Court. I said, you need a separate whole day on the Concord as an institution. Remember that the Concord is, in terms of our Constitution, I have postulated this opinion publicly. I don't know whether the lawyers here disagree with me, which will be fine. Ultimately, it will always go to the people. Even in terms of the current constitutional provisions, it says if you alter the provisions of the structure of the judiciary, in terms of section 89(4) of the Constitution, once the phase 1 of the National Assembly finishes, there is the last part. And that last part is to ask the people, what? Do you agree? If they say no, what happens to that law? Is the end of it. Because the Constitution says anything that interferes with entrenched provisions, referendum is required. And the restructuring of the court system is an entrenched provision. So you need to go to the people. The people will debate. They will either say, we want the Concord now. Yes, or they will say, by the way, by voting that we want the Concord as part of the constitutional review process, we are not necessarily rejecting the institution called the Concord. We should not conflate people rejecting the institution and the process part. Per se. So, I think I have answered the questions. You know, in the period that I gave of 2 or 4 years, some countries have taken more. But I think if your country is efficient, it can afford in 2 years to have it all done, wrapped up, or 2, 3 years, up to 4. Thank you very much. To get our country talking and debating massively in every corner, but in an organized and structured fashion. And that education that will come out of it will probably be the best that we have ever done for ourselves. We need to free ourselves to be tolerant and let people speak and finally be driven to some agreement, even if there is compromise. So that potential is still there. It can be achieved. Nakara already be a bua. Kiwana hori matichara kana le utama ile shakes. Then the president opposite. Kiwana hori le habertaba. The first, I think it was a comment. One of the participants was a former president of Civic. Was talking about that are we going to kill the peace? I think he was basically speaking to the colonial constitution. I think we should say this, and I think in my writings I've made this very clear, that the colonial constitution did serve us well. It served us well for as long as we used it in some respects, not in all respects. I did mention the foundational flaws of that constitution, from the genesis of its creation, starting from who designed it, who were at the talks. And I talked about it leaving aside no women and other stakeholders. It was faulty from the beginning. It led to generational injustice over time, arising out of the way it was crafted from the beginning. But it did deliver peace to us. It delivered stability to us. And the sovereign, the people themselves, is within their capacity and powers to grow and develop that constitution through the review process. So it's a comment on that commentary. I think we shall say something that was very brilliant. This constitution belongs to you. It does not belong to politicians or to whoever. I've never heard anyone, they can't say, no one can say. In fact, I challenge anyone. No one can stand and say that constitution does not belong to you. No one can say that. No one. Because no one can say that, it's exactly the fact that we expect our politicians, our leadership to guide us the right way. To unite us and not to divide us, to be true leaders in that sense. And allow us to disagree with each other. And after disagreeing, facilitate through some other mechanism like the independent constitutional review mechanism of being guided towards reaching some agreement. Many of you, including Radibile Sheikhs, they've been involved in salary wage negotiations. I hope the 15%, whatever. But we have also had them coming out of that barrier 5. This drives the point home that you must talk. You must talk and agree on a compromise. So that comment by Mr. is spot you. You will make your constitution, we shall guide and facilitate because we are the leaders. And then there was the case, I think, Basukh. Yes, on rights of the marginalized. He was referring to some commentary called obiter in law, meaning a statement that is not binding of President Kirby in the case that he referred to, that must be careful that judges do not overly, interpret the Constitution. It's something that I spoke about. I said one of the clearest way of ensuring that judges are not burdened with interpretation and bringing into the Constitution that which maybe the people didn't like is to make the Constitution clear what you want. Clear. And say that which you don't want. If you suspect that this interpretation, some judge may one day say it means this, put it in the Constitution that by this we don't mean that. And that is where I said about drafting, right? About the importance of drafting. I say it's a key component of the constitutional process. If they anticipate, that's why the experts come in, if they anticipate ambiguity that maybe 10 years down the line, one judge may say this, but this is not what we mean, put it in the Constitution. And in that way, you address those things. Because there is always a danger when you entrust judges to legislate. Students of constitutional law will know that some years back, the Constitutional Court redefined the definition of marriage, right? It used to be a union of what? Yes. What did they define? How did this court define it? A union of two consenting adults. So it speaks to your point about interpretation. If you fear that may be the case, be clear. Remember I said earlier when I was responding to Moise, I said in Botswana, the reason why even if there are judges who don't like the death penalty, they can't do anything, is because the Constitution itself is clear. It says, when we say the right to life, we do not mean that the death penalty it offends the right to life. So, in fact, these days, there is a big movement towards simple language in documents that govern people's lives. No jargon. Be plain, be clear. The judges should have no excuse to say that this was unclear. Yes, I think I have answered everyone. Thank you.
The online ones?
Oh, there's the other written. They were written here. This is a very interesting question. I'll read it so that the lawyers here can answer it. It's a very interesting question, actually, this question. Matlop. Who is Matlop? Online. Is asking, is the rightful constitutional process protected by law, allowing for a legal remedy should the process go on? If no, what other options are available for the people? Chuchu, you want to say something? We must all talk anyway. Yeah. I'll have my views. Oh, I should read it again. Okay. It says, is the rightful constitutional process protected by law, allowing for a legal remedy should the process go on? If the answer is no, what other options are available for the people?
The available remedy and process for the people is participation. That's the greatest solution in medicine. Once the people participate, then you have the remedy, you have the solution. Then nothing should go wrong because the people have participated. Where we may differ is how do the people participate? Because some will say, Kika Morero, a comprehensive consultation. Some will say, well, if I choose my leader, I've participated.
there are other options.
Thank you. Let me give an answer. I'm assuming there's an assumption here. If the question is whether under our current constitution we have any clause or law that governs how the constitutional review process should be done, the answer is no.
No.
If the question is whether if any law passed by Parliament is done in a manner that violates the Constitution, whether there is anything that can be done, the answer is yes. And what I'm saying is that if, for instance, the Constitution, section 89(4) of the Constitution says, if you want to alter this entrenched provision, you go to the people, and you don't go. The people can go to court and complain about whatever they want to complain. Their complaint will be that that is wrong. Therefore, either declare that that is wrong, it cannot be law. Right? So the constitutional review itself, in terms of whether there is a clause in the Constitution that spells out how that process should be done, there's no such provision. Can Parliament do whatever it likes to do? The answer is no. They're bound by law. So that, I think, answers that question. This other one, the handwriting, I don't know who can read it for me.
No, I'm trying to
They're saying that youth parliament that is politically unfulfilled. Hashtag Kalai.
Can I give it to the owner because he's in the room?
I don't know why he's giving us such a task. Sir, can you please read your question?
Yeah, you can ask the question.
This is yours.
Good afternoon. Usually, I have a habit of writing in a manner that no one can read. Not really, it's the handwriting I'm used to. Your Lordship, question that I wrote here, it's related to young people. So before I read it, I would like to ask the audience, especially the young people, I want to see how many of them are here. So can they kindly raise their hands? Let's say those who are below 35. Your Lordship. We don't want this kind of inclusion in the Constitution. Sorry? Now, the question that I wanted to ask is one that has pitted the majority of us who hold at least 60% of the population of this country. We are often excluded in decision makings, in the public space. It's very rare that we have a gathering like this where we actually have those who have actually studied the law to come and educate us, have us to express our opinions, to understand where we are coming from, what is needed, because we are the ones who are going to inherit this country very soon when
You die.
So the question that I wanted to ask directly was, in this constitutional review, is there a possibility that a youth parliament could be established, that which is going to be politically unaffiliated with any political party, to ensure that young people getting those platforms, debate, raise those bills, so that tomorrow they know that the decision that is taken by either parliament or the law itself, they know that they are included in it, they are not excluded, so that tomorrow they can be able to use those resources that are available to accommodate everybody else in the future, not only just right now, because we are nearly and every time we are excluded in most of these participations. The leader of opposition knows that directly. I've often spoken to him about it online, and I was supposed to meet up with him yesterday. Yes. Afternoon, sir. So I don't know if you can articulate on that, whether or not is there a possibility, if you have no process.
It's on the youth parliament. Was your question whether it can be included in the new constitution?
Yes.
Yes. I'm formulating an answer quickly. The design of the constitution and what goes into the constitution is a prerogative of the people. In the constitution, the people design their own institutions and they put them there in the constitution. Let me just give you an example of South Africa, for instance. They had the Human Rights Commission, the Gender Commission. Did they have also the Media Commission? So they put these institutions that they consider important to support democracy in the constitution. I said earlier that any country in crafting its own constitution is not tied to any model. The people can create their own constitutions. Just to give you an example, currently the House of Chiefs in Botswana, you know, Botswana has two houses of bicameral parliament. In terms of the colonial constitution or the independence constitution, the houses are advisory, right? But there's nothing stopping people to change that. And there's nothing stopping people to create other institutions that are currently not in the constitution. Have I answered you? So I have avoided specifically, which may be a point of unhappiness, but I've answered. I have specifically avoided saying you can put the youth parliament in the constitution. But I've said that the people have the prerogative to create the institutions they want and put it in the constitution. If you want me to please you, if the people conclude the argument, if the people resolve that that is the structure they want in the constitution, no one will stop them. In short. When I got to PNG, I'll give you, when I got to PNG, I was used to coming from a secular state. Botswana is a secular state. So I was given an appeal to do against the decision of the Deputy Chief Justice who had convicted some fellow and sentenced him to many years in prison for fraud. And in the judgment, among other things, the Deputy Chief Justice said that you'll have to go in for this number of years in prison because what you did offended the laws of PNG and also offended the laws of God. And because the Bible says, thou shalt not steal. So I was coming from this background of Botswana constitution that doesn't say that. And I was on the verge of dismissing, I was on the verge of actually upholding the appeal as a misdirection. Fortunately, I had to caution myself to read further. So I consulted the constitution of PNG again, and it said PNG is a Christian state. You see what it does? It actually comes back to your question. State that which you want in the constitution. So after I read that, I was sitting with the Chief Justice in the panel, and he said, your views of yesterday, have you abandoned them? And because I said, yes, I have. I'm no longer going to uphold the appeal because there is constitutional basis for the Deputy Chief Justice invoking the Bible. There is a constitutional basis. The constitutional basis is that PNG is a Christian nation. So every nation has the authority to craft its constitution. So, yes, thank you very much. That's my answer. He had also wanted the leader of the opposition to answer the question.
Before we take the last round of questions, I'd like to also recognize Dr. Selebatso, who's the vice chairman of Okongo. With that, we'll move on to the last round of questions.
Thank you very much, and thank you, Your Lordship, for the very enlightening presentation. My name's Rose Nunusaret. I'm here as a student, though I'm in my evening of my life. But I just want to talk about the point that you mentioned about the previous process which used the Commission of Inquiry Act. And to say, okay, much as it was flawed in that it used the Commission of Inquiry Act, can we put that aside and say we take all the consultations that came through that process and use them and look at them instead of going through a completely new process again? Rather just say, let's take what came out of that process and use it, and put aside the fact that the process itself was flawed. Thank you.
Yeah, I position myself strategically. Nickname accused number 4. Get my Dr. Every other thing you know, I see where was done. Hey, man, maybe practice law for over 20 years and put a lot of bad guys in prison. So, don't mention. Yeah, not that I mean, it's you so succinct, so clear. Osenama hokwa atata mo kwena kere modimo ho keletse re ne le sa publish because ebile ne tsa go nka le dira meditsi ba batho ba ha ba itirile sentle go tlhoka go attend the incidents dintsinya and it's so sad but me hela ne kere jaaka hela sa go bua tota go harologana ka maikutlo ga wa tsona go mo sa batho maikutlo kana go tlhweyo hela the example you just given gore ono then you went to read and inform yourself. Then after informing yourself, now you need to change things. Look, which change constantly. I told somebody, no, you be or you were a judge. I don't want to Ulugumurake, why Diva, don't know myself. Sigilumurake for 3 years. Mera Sigabatan was doing I told some guy can and then he said, no, maybe I go help this code to reading a expert. You talked on it, that's you've been explaining. You talked on it, but I already explained it about for the benefit of people. He sent me through a phone, a prosecutor's insight on the current unfolding discourse on constitution. Then goes to say in Latin outside, justice, non justice, dire. Our duty is to declare the law, not to give it. Full stop. In the process, they make laws through judicial precedents. I pause to rest my case so that you may be expanding. Thank you.
Good afternoon, my lord. My name is Joshua Bethuel, and throughout the deliberation today, I've heard a lot about the Constitution involving the contribution of the people. But my question now comes, what happens when we, the collective, are wrong? Because we come from a society that at a point in time did not allow a child to inherit, particularly just because they were born from an unmarried couple, or did not allow a woman to even in such a setting to be able to stand up and speak because a woman was considered a perpetual minor. So in such a situation where we, the collective, are wrong, who then stands to correct us? If all we're going to create is the views of us, when we are wrong, then what happens from there? Thank
you. Okay, good day, guys. My name is Laura Manenye. I'm a fourth year student for UB. I'm doing a double major in political science and psychology. So my question is solely based on what you said about the separation of powers. In Botswana, it's possible that an individual can be submitting to be an MP, a minister, a vice president, you know. So this fusion of powers is possible to weaken the parliament's, ability to do checks and balances. Like, is it possible for the constitution to be amended to strengthen the separation of powers? Like, provide a system or an arrangement to, make the parliament genuinely hold the executive really accountable rather than absorbing it. I don't think that's possible, but
Chance to ask a question. Her question was the last. I'm the master of ceremony. I don't know why. This is a dictatorship. So we are already behind time. We must have another. We are going to have a panel here, and they are already waiting for their time. So you will be make it short, sir.
Hello. Did you go to the chair? I've noticed that Botswana, we have a lot of good ideas, but the implementation is a very big problem. And I look at other countries that go Maraho and we try to operate. Sometimes, the politicians, they move very, very fast. And then about to go Maraho. But people in Botswana right now, social media, so in short, it's public education, and I think that I have been in the public education sphere area for a very long time. Who educate and influence behavior. We are never ever very, very good at that. But countries like China, Russia, and all those, at that time, 100% of propaganda when they used to really influence that people. But I am saying that, can you please step up the public education campaigns more, especially in this, on this thing. Thank you.
Well, it's a good thing that it was a comment.
Thank you very much. What happens when we, the people, are wrong? It's a very profound question. The answer is that it must have been Winston Churchill who said, democracy is imperfect, it has flaws. Humanity has not managed to devise a better system. What is my answer? My answer is that when the majority are wrong, then democracy says they must prevail. But over time, with the development of constitutionalism, what has happened, the whole idea of constitutions and constitutionalism and the rule of law, which means three different things. Constitutionalism has enabled, it's a mechanism by which we must also avoid, even within a democracy, what we call majoritarian tyranny. Must avoid the tyranny of the majority. So certain mechanisms are put by constitutional lawyers in the design of the Constitution to ensure that wherever possible that is mitigated, but it can't be eliminated. But I like the question. It gave me some ideas about my next class somewhere. I like the question. That's why I started with it. Rose asked a question that I am not competent to answer. Whether you want to resurrect, is it possible to rely on the flawed findings of the commission that has gone before? My answer to you, Rose, is that let our people determine that question. But if I were to answer legally, lawyers may remember a case and the famous statement by its prominent judge, Colonial. He said, that which is a nullity in law is a nullity. Nothing can come out of it. So I've answered you in that way. Our duty, is that what it must have been Bruno conveying the sentiment of a prosecutor. He said, our duty is to declare the law and not give it. There are many schools of thought around that quote. Some people say that the law as written by both the Honorable Leader of the Opposition in Parliament, Barry, is potential law only. Meaning that when it goes further to the courts may say it means something, but that which they never thought they meant. Actually, I've seen it in actual. So it answers the question. The separation of powers says that we must interpret, but often in the course of interpretation, we make the law. So there is a whole lot of debate between many judges around that. I have a full chapter in one of my books, Do Judges Make Law? It's a whole chapter, and it answers that question. The answer is yes, they do. They do, but they do it through a route of interpretation. And I call them, they are not the primary lawgiver. The primary lawgiver is Parliament. But the judges will intervene and say, this law is tainted with absurdity. Or the consequences of applying it are so absurd that no reasonable Parliament could have intended it to be. And when they say that, then they can overturn that law. So Bruno, I hope I answered your prosecutor friend. Our duty is to declare the law, not give it. Is the standard wisdom. But sometimes we do give it. Unity DAO versus the Attorney General is one example. The debate that involved everyone was whether the fact that in the list in section 15 the word sex is not there, does it mean that you can discriminate based on sex, right? What the Court of Appeal says, they say, no, even though sex is not there, we now interpret this section to mean you can't discriminate based on sex. So they put it there. And subsequently myself, in the case of Korai versus the Attorney General, I extended the list. I said you can't discriminate based on marital status. It's not in section 15. India versus BBS, I extended the list. I said you also cannot discriminate based on health status, but it's not in that section.
If I'm referring to the judges to the judges make the law.
Yes, Larona. You remember Larona said that we have separation of powers, but the Constitution doesn't say. But we do. The judges say it's there. In reviewing the Constitution, I think one of the things that many of us would like to see, myself personally, is that there must be a clear statement. There shall be separation of powers. The people can determine whether they want to create an arrangement in which that fusion that you talk about is not there. The people can say that there will be total separation, no member of parliament will be in the cabinet. The people can say that. So the people in the Constitution can say exactly that which they want. They can avoid fusion of power, they can sharpen separation of powers. It is their prerogative. In the case of Setsoho versus Botswana Railway Organization, which I initiated with the Industrial Court, the separation of powers was debated seriously. Read the 5-man decision. And they said in Botswana separation of powers is loose. They characterize it as loose because a member of parliament is also a member of the executive. So you may want to, in the new constitution, say no, we are not going that route. It's up to you. Thank you very much.